Welcome to the program. Good evening. My name is Karen Karimi and this is Friday, a show that brings together Kenyans here and abroad to share their life story, journey and success with us. This is a home of untold stories. You can watch us on DStv, Zuku, StarTimes, GOtv and live on Facebook and Twitter on TV47 Kenya. Our guest tonight is known all over social media as Swahili Food, and she is live via Skype all the way from Muscat, Oman in the Middle East. Good evening, Vanessa. We appreciate you finding time for us. Kindly introduce yourself to our viewers and even better in Kiswahili.
Thank you, Karen. Jina langu ni Vanessa Mehri. Nililelewa Pwani, that's Mombasa, Kenya. Na ninaishi Oman, Muscat, Oman, na mume wangu na watoto wangu watatu tangu sasa miaka 6 sasa. Na nimepika kwa zaidi ya miaka 15 hivi.
Your Kiswahili is great, Vanessa. You don't want to miss that interview and get to know more about Swahili Food later on in the bulletin. Stay tuned for that. But first, the day's highlights this 2nd of September.
Tonight, curtains come down on 3 days of legal showdown at the Supreme Court as judges retire to come up with a judgment with far-reaching ramifications.
We will deliver our judgment on Monday the 5th. We shall give you notice closer to that day.
Also tonight, Azimio presidential candidate Raila Odinga maintains election technology was infiltrated.
Which means already, by calculation, there is a problem. But we'd like the court to look at the total number of registered voters.
And that the results declared did not reflect the will of the people of Kenya.
What does the chairperson of the Electoral Commission do in the circumstances, not only of this case, but even in previous occasions?
Plus, the Supreme Court releases a damning report on vote recount and access to election servers. That had lawyers battle it out in court in the last day of the hearings.
Welcome to the program. Now to our top story. The pensive wait begins for Deputy President William Ruto as the Supreme Court delivers its decision that could either send him to State House or back to the ballot. His lawyers used the last day of hearing to demonstrate to the court that President-elect was validly elected, as Florali Muki now tells us.
Madam President Judge.
On the final day of the proceedings and the day earmarked by answers to questions by judges to both the respondents and the petitioners, on the question of the quorum by the IEBC and whether the lack of it thereof had an impact on the declaration of the president-elect, Ruto's legal team, led by Professor Kithure Kindiki, responded by saying that provisions in law make their walkout inconsequential as far as the realm of the IEBC chair on his mandate as the one to declare the presidential election winner.
Can the walking away of commissioners at the tail end of a process they have been involved in be the basis of vetoing the right to franchise in Article 38 of the Constitution, which is the expression of the voter?
President-elect's team also refuted claims that IEBC Chair Wafula Chebukati was wrong by announcing the results amid chaos that rocked the National Tallying Center, and if he was under any pressure from the Kenya Kwanza wing to declare William Ruto as the president-elect, citing that he instead was fearing for his life since other commission officials were abducted.
Their colleagues had been injured, and so the chairman had, in our view, make the announcement that day because of the gravity of the situation.
Ruto, through his lawyers, also refuted claims that there was rampant doctoring of Form 34As by Venezuelan nationals, further clarifying that the forms submitted to the court in lawyer Julie Soweto's submissions were different from the hard copies of the same.
The sensational reporting that was made was intended to convey a picture which is to the opposite of what the form now before the court conveys.
While at the same time clarifying on what they know about the visit by the National Security Advisory Committee to the Bomas of Kenya in the morning of August 15th, and if it could by any way have an effect on the outcome.
But to try to interfere with the declaration of results and thereby try to alter the sovereign will of the people of Kenya.
President-elect William Ruto is now a man under the weight as he looks forward to the decision that could either send him to the State House or back to the ballot. Flora Limuki, TV 47.
Azimio la Umoja presidential candidate Raila Odinga insists that the election transmission technology was infiltrated in a bid to influence the outcome of the election through his lawyers, including Julie Soweto. Raila maintains the will of the people of Kenya was not reflected in the declaration of William Ruto as president-elect, and instead it was the will of Venezuelan national Jose Carmago.
In a spirited last-minute attempt to overturn the win of President-elect William Ruto in the August 9th presidential poll, Azimio la Umoja presidential candidate Raila Odinga insists that the election technology failed the integrity threshold.
We'll deal with all the questions that were asked by the court.
While seeking to respond to questions raised by judges on Wednesday on some of the grounds of their petition, including how the election process was used to reduce his vote.
My lords and my ladies.
While responding to the issue of authenticity of Form 34As on the IEBC portal, Odinga, through his lawyer Julie Soweto, sought to provide evidence of the hacking claims while placing the now infamous Venezuelans.
At the top left-hand corner there is the name of one of the Venezuelans, Jose Camargo. This is the person who decided the president-elect of the country.
Plus also showing the courts how the KIMS-KIT system could have been used in their claim of infiltration of the Form 34A transmission to the public portal.
Yes, you can see. It's okay. I want to produce the Form 34A, the original Form 34A.
The move caused a stir in the court while IEBC and DP Ruto lawyers fighting to the nail to expunge the record from the proceeding in court owing to their grievous nature. In their rejoinder, however, IEBC through lawyer Mahat Somane allayed the claims by providing the original hard copy in the court.
We submit that that is not true, and that is an overlay that someone who has taken the picture. We will give the court the Form 34A to compare with the original 34A with the certified copy that the court has.
Odinga, the main petitioner, remains on the edge as he awaits the Monday decision that will either ratify his fifth loss or give him a political lifeline. Paul Munio, TV 47.
Also tonight, the advocates representing IEBC Chairman Wafula Chebukati and Electoral and Boundaries Commission in the just concluded presidential election petition insist that the chairman delivered in his constitutional mandate and didn't fail in any way, as alleged by Azimio One Kenya faction. Led by Senior Counsel Professor Githu Muigai, in responding to the critical questions raised by the seven-bench judge on the conduct of the chairman and commission, the results transmission among others, the advocates insist that the August 9th polls were free and fair.
In their last day of submissions on election petition seeking to annul the presidential results as petitioned by Azimio candidate Raila Odinga and running mate Martha Karua, the IEBC advocates and those representing IEBC Chairman Wafula Chebukati insist that he acted as per the constitution and didn't fail in his mandate. Answering the questions raised by the seven-judge bench, the advocates braved the question by Justice Isaac Lanaola on why Chebukati decided to announce the results on 15th and not 16th August when the chaos at the Bomas of Kenya could have been quelled. In their response, the lawyers say Chebukati had to make the decision to end his tribulations of fearing for his life after some of election officials were abducted.
Upon the chairperson of the commission to declare the result. So the gazettement was not for purposes of Article 138(3)(c), but specifically for Article 138(10) to fulfill that role. to take up that responsibility to account for that result that follows a presidential election. That is the specific purpose for that gazettement. But while I'm on this question, I would also want to pose another question. Would it then mean that if the Gazette notice was to fall away, would it then mean that the chairperson of the commission under Article 138.10 would not be in a position and suffer lack of constitutional authority to declare that result? My answer is no.
On the question of transmission of results by Justice Smokin Wanchala, especially on transmission beat and the involvement of the Venezuelan citizens in the whole process, the lawyers further told the courts that there were no way one would infiltrate their servers. Lawyer Mahat Somane dismissing the demonstration by Azimio One Kenya Defense.
If you look at the scrutiny report and if you look at the QR register which is in those boxes, you will actually find the name of Jose Camargo on the register that has been printed. We've also produced the original Form 34A. We've come with the receipt. And we're being told that you cannot produce your original 34A, that Jose Camargo was interfering. And in fact, if you look at the numbers on the original 34A, it's the same as what the picture of the overlay was taken. So to the question that someone called Jose Camargo was interfering with the portal, it's actually not true. It's incorrect. And the attempt to prevent that evidence to the court.
On the role of IEBC chairman and the commissioners as raised by Justice Njoki Ndung'u and the conduct of the IEBC chair in the whole process of election, lawyer Professor Githu Muigai defended Chebukati in what he says cannot be equated to other commissioners, dismissing dictatorship allegations leveled against him.
Here, as we have seen, this commission is extremely hands-on, and for that very reason, its chairman has executive power. It is very similar, Melody, to the JSC, the Judicial Service Commission, which in theory is a corporate body. In day-to-day functioning, the Chief Justice has executive authority and makes many decisions in the name of the JSC, as it should be, because it couldn't be run in any other way. Thank you.
The 7-judge bench is expected to deliver their ruling on Monday next week after retreating for 2 days. Elizabeth Mutuku, TV47 Nairobi.
Now, the 4 dissenting IEBC commissioners who distanced themselves from the commission after they disagreed with the 2022 presidential election results have today submitted through their lawyers that the chairperson isolated them from the verification and tallying of the results. And as Elizabeth Atieno now reports, lawyers of the 4 commissioners today responded to a question addressed to the dissenting commissioners by the 7-judge bench.
On the 15th of August 2022, during the declaration of the presidential election results, 4 commissioners of the Independent Electoral and Boundaries Commission, including Juliana Cherera, Francis Onderi, Irene Masit, and Justice Nyang'aya, left the Bomas of Kenya for a 14.5-kilometer journey to Nairobi's Serena Hotel, where they rejected the results, citing opaqueness or lack of transparency in the last phase of the election process. The split within the commission was seemingly one of the areas of interest for the judges, who sought to understand the reasoning behind it and its impacts, if any. On his part, Judge Isaac Lenaola sought to establish whether the walkout of the 4 commissioners was an afterthought, and if the 4 commissioners could prove that there was a problem in the commission months before the August polls.
Once again, there were protests, but the commissioners took the firm view that it would responsible for them to let their infightings be made public for fear of eroding public confidence in IEBC during an election year.
Deputy Chief Justice Philomena Mwilu, on her part, sought to establish if the commission was dysfunctional and at what point the commission stopped operating as a corporate entity.
The correct position is the Commission continued acting as a corporate entity, but it had serious corporate governance issues. And this is confirmed by the fact that they were able to deliver a general election, they were able to train presiding officers, so the Commission continued working as a corporate entity with the Secretariat and the team behind it.
Chief Justice Martha Koome wanted the dissenting commissioners to identify steps taken after the issues arose and why the display of the presidential election results suddenly stopped.
When you look at the replying affidavits of these 4 commissioners, all say the same thing. That public display was stopped by the chairperson, and they requested him to resume the display of the results, and he declined.
In their affidavit, the 4 commissioners accused Chebukati of breaching Articles 88, 248 and 249 of the Constitution after he failed to meet standards of transparency, accountability and independence of IEBC. The 4 commissioners expected to serve a 6-year term were appointed in September last year to replace Commissioners Consolata Nkatha, Margaret Mwachanya, Paul Kurgat and Roslina Kombe, who resigned after the 2017 polls marred the nullification of the presidential election outcome by the Supreme Court. Elizabeth Atieno, TV 47.
Now, the question on whether President-elect William Ruto attained the 50% plus 1 vote as stipulated in Article 138 of the 2010 Constitution played out at the better part of the day in the Supreme Court. Azimio leader Raila Odinga, through lawyer Otiende Amolo, told the court that no presidential candidate had the required votes. IEBC and Ruto's lawyers, however, argued that the tallying process was done according to the law.
Azimio One Kenya presidential candidate Raila Odinga, through his lawyer Otiende Amolo, has told the court that no presidential candidate achieved the 50% plus 1 of the votes. The reared member of parliament at the same time accused IEBC of trying to falsify the voter turnout in a bid to alter the votes for President-elect William Ruto. Reiterating his sentiments, petitioner Okiya Omtata said that IEBC chairman Wafula Chebukati cooked the numbers he gave to the public.
I'd like this court to take note of how the percentages are being played with. That's slide number 10. You will find that whereas the chairman is reported 12,065,803 people voted, who voted represented 56.17 of the total registered voters of 22 that. At paragraph 26 of the replying affidavit, Mr. Sunkuli, using the same number of voters, 12,065,803.
The Electoral Commission, however, clarified the total number of voters who were recorded on the 10th of August 2022 being 64.6%.
Coming from 34As, those numbers that are finally tabulated have to, because of the biometric voter identification, they must tally with the number of people who turned out to vote. So when you're looking at those, so when they give a percentage of the number of voters who voted, and you look at the tabulation in the final from 34C, those numbers have to merge, and they have to make sense.
While representing Youth Advocacy for Africa, Tom Macharia called out IEBC for filing wrong numbers on the stray ballots.
Number, for starters, is not an accountable figure. What they've done, and you'll find that, I think, at paragraphs 73, 74, 75, and 76 of the chairman's replying affidavit in our petition.
A ruling on the petition is expected Monday, even as the Martha Koome-led bench will be retreating for the next 2 days to write their judgments. Stanley Nyaringita, TV 47, Nairobi.
Now, Azimio leader Raila Odinga has maintained that the counting of votes was not transparent since foreigners were allowed by the Independent Electoral and Boundaries Commission to access the server, and that saw the altercation of results from the portal. In a rejoinder, the IEBC and William Ruto have refuted the claim, saying the process was open and that no evidence has been placed to impeach the Form 34As. Chapter Boyd with the details.
Azimio leader Raila Odinga's lawyers and other petitioners watered down the court-sanctioned report on the orders of access to the server and scrutiny of votes from 15 polling stations, which raised a heated debate on the tail end of the presidential petition hearings. According to lawyer Willis Otieno, 50% of Book 2 of 2, which were not supposed to be used, were used.
Mr. Chebukati single-handedly directed for Book 34 2 of 2 to be printed, and Book 2 of 2 having been printed, it went out to the stations. The Gazette notice required it not to be used. It was used, and the registrar's reform has confirmed.
Raila Odinga has also faulted the IEBC for failing to open access to all their servers, and in what they say they were able to access, there were deletion of logs, and that indicates that the server was being accessed by foreigners before and after the election.
And I must apologize to bring the bad news not only to this court, but to the entire Republic, that those logs contain active participation of foreigners on the results transmission systems of IEBC from the 15th to the 16th of August, 15th of July to the 16th of August 2022.
When we asked, as the court had directed in its ruling, order number 1, that we get a password policy, they said no, it will infringe on the security. And that becomes extremely important in terms of knowing who had access to those servers, in terms of confirming the the code or the policy on change of passwords. They refused to give that information.
In a rejoinder, IEBC and William Ruto's lawyers have dismissed the claims, pointing out that IEBC complied with the court order and that their recounting matched the results announced by the IEBC, save for slight errors.
We fully complied, save for providing the owners of system administration password. The order issued by the court had a security exception, but if it was determined it was too risky to provide something, we were to object and provide an explanation.
It also confirmed that the Form 34As were not altered as it has been submitted before you. I therefore do submit that there are no irregularities in terms of the votes cast against each of the candidates in this particular petition.
I appreciate that the purpose of scrutiny is an exercise that is meant for the court to have an impression of how the exercise of the election was conducted. And that's what you said in 2013, Raila.
The report by the Supreme Court Registrar after the scrutiny process is among the factors that will determine the final verdict to be given by the Apex Court on Monday, while Raila Odinga and William Ruto cross fingers as the country awaits who the axe will fall on. Chipto Buich, TV 47, Nairobi.
Now, the team led by Githumwe Guy have maintained in their final submissions that at no point were there any attempts to log into the servers. While speaking before the judges, he maintained that there was no attempt to delete any file from the server. On their side, Azimio's lawyers emphasized that there were deletions on the servers.
My Lord, just a quick one. The page you refer to as R10 appears to look very similar to this page 16 that I had provided. All I'm saying is that relates to dates in July, and what we received from IEBC contains logs up to the 31st of August. But the two last entries in August 31st and 24th are attributed to Root, who we believe is one of the same gentlemen. But the one I referred to today was August 16th. So it's just a question of how long the log was. Check again on your side. And then finally on the issue of the deletion, our position is that there was obvious deletion, and what we found there was empty, recently modified file, and certainly not a server that could hold the entire election in the Republic of August 31st and 24th are attributed to Root, who we believe is one of the same gentlemen. But the one I referred to today was August 16th. So it's just a question of how long the log was. Check again on your side. And then finally on the issue of the deletion, our position is that there was obvious deletion, and what we found there was empty, recently modified file, and certainly not a server that could hold the entire election.
Now, also tonight, details of the damning report by the Supreme Court on how the electoral body, IEBC, fared in granting access to its servers used during the August 9 poll, and a repeat vote count of 15 polling stations can be revealed. This is after the report tabled in court today revealed that 9 polling stations used Book 2 of the controversial Form 34As, while 6 other polling stations did not present the forms. Political parties had protested the printing of the second set of forms in July. Apollo Kamal has that report.
Here,
The crucial report compiled by the Supreme Court Registry under the leadership of Supreme Court Registrar Letizia Wachira and to be used by the Apex Court in making its final decision on Monday has found no major discrepancies, save for the controversial Book 2 of the result transmission forms, Form 34As, that elicited protest from the Azimio camp before the August 9 general election.
What is important and material is from the scrutiny that was undertaken until very early hours of yesterday morning, the result matches what is contained in Form 34A. And my Lord, those Form 34As have been availed to the court pursuant to the rules of the Supreme Court.
The report, which is a summary of a vote recount and access to IEBC servers, was ordered by the court following a request by main petitioner Raila Odinga and Mother Karua, singles out 9 polling stations that used the second set of the controversial Book 2 of Form 34As, while 6 polling stations failed to provide the forms. According to the report, returning officers from 6 polling stations that did not provide the forms said presiding officers mistook the 2 books as they did not understand the procedure.
Some of the forms are not there. And even the report will bear it out that some of the presiding officers made mistakes in Book 1. They cancelled it and utilized Book 2, but still the result did not change.
On the server access, the report said IEBC complied with the court order, having granted supervised access to the live server through an interactive session, including access to logs and form scrutiny. A total of 15 polling stations were probed by the Judiciary Technical Team. Apul Kamau, TV47.
Now, former Meru Governor Kiraitu Murungi has decamped to William Ruto's Kenya Kwanza camp. Kiraitu blamed the Azimio One Kenya Coalition Party for his first election loss in 30 years, now saying that he has shared ideologies with the president-elect.
Former Meru Governor Kiraitu Murungi's Devolution Empowerment Party has changed route to join the Kenya Kwanza Coalition under President-elect William Ruto. Kiraitu said his ideologies and those of Ruto are aligned and expressed his willingness to work with Ruto moving forward.
I come here as the Mbas party to join you and the Kenya Kwanza Alliance which you lead as we embark on this important journey. The Mbas and the Kenya Kwanza Alliance have no ideological differences.
The long-time Meru politician blamed the Azimio One Kenya Coalition Party for his resounding loss in the just concluded Meru gubernatorial contest, which he lost to independent candidate Kawira Mwangaza.
The bus ride in the Azimio coalition has been bumpy and slippery. Some of us lost the last election because of darkroom intrigues and internal sabotage by some actors within the Azimio coalition.
On his side, Ruto accused the Azimio faction of using threats and intimidation to push their agenda, something he says will have no place if he forms government.
The tools they have used to build their coalition will not be available to them because we have made a commitment that going forward, the provincial administration will be a professional organization that will not serve any political party, but will serve the people of Kenya. The offices of the DCI and EACC will not be available for the use by any political party. They will serve to make sure the resources of the people of Kenya are used for the intended purposes in a transparent manner, and no Kenyan will be hounded by our criminal justice system.
We have always been one team. Isipokuwa ni shetani alikuja ile match that day akatuingilia hata kutukoroga, because we have tried to analyze this whole situation. Ni shetani peke yake, because we cannot understand.
Kiraitu's Mbas party won 13 MCA seats in Meru, which will add to Kenya Kwanza's 14 seats and give Ruto the upper hand in the county assembly. Kiraitu's move to Kenya Kwanza is only the latest, with the newly re-elected TRT MP William Kamket having decamped to Ruto's side on Wednesday. Waris Kimathi, TV47.
Now, with just 3 months to the first transition to junior secondary, teachers and parents appear to have more questions than answers on how the government will ensure that the selection process favors learners. Grace Ngure with more.
As the clock ticks towards the grade 7 selection deadline, the transition of students to junior secondary schools has left many parents with more questions than answers. Among the issues raised include the criteria that will be used by the Ministry of Education to allocate learner spaces in various schools, especially the national secondary schools, yet there is no grading of learners.
We don't know the criteria that will be used to place our learners in various junior secondary schools, because in the 844 system we've been using marks.
Issues of some school missing in the online portal where the parents are supposed to help their children apply for these schools has left many parents worried.
You realize that you are interested in a particular school, and this school, when you go to the system to select that particular school, the school has been approved, yes, but when you go to the system, you find that the school is not there in the system.
It is a situation that has also left teachers at a crossroads, especially those in private schools who now say that the government should be clear in the involvement of private schools in a transition plan to junior secondary school, which is 3 months away. Besides the selections headache, most parents are not comfortable with the fact that the younger kids will be forced to mix with the older learners already in the secondary schools.
The question of age of the learners transiting to junior secondary school, you find that some of them are still very, very young.
While responding to the concerns, Magoha has urged parents to enroll their kids in the day schools to avoid being worried about turmoil in schools.
So if you want your child to be near you, look for a day school near yourself. But if you are bold enough, like those other bold parents who sent their children to faraway schools and they basically behaved.
The Ministry of Education extended by 10 days the registration of grade 6 learners who are transitioning to junior secondary schools. Grace Ngure, TV47.
You're watching Friday with me, Karen Karimi. We take a short break. We'll be right back with more stories, sports, and our Friday interview with Vanessa Mary.
TV47, the home of untold stories.
Sona moja imetengenezwa kwa njia spesheli ili kupambana na maumivu kwa haraka. Sona moja ina aspirin kama kiungo. Sona moja, kitulizo kamili. Maumivu yakizidi, pata ushauri wa daktari.
Tryson School of Medical Health Science and Technology is a premier training institute for market-driven courses. With state-of-the-art facilities, competent and dedicated members of staff, and linkages with the medical industry, you are assured of a bright future when you study with us. Enroll today in our campuses at Juja, Nairobi West, Kisumu, and Homa Bay.
Kaluma King Herbal Lozenges zinazo nguvu maradufu kutuliza kikohozi, vidonda vya koo na mafua. Kaluma King ni shwari.
Tika mama huyo muharifu kaiba kuku zangu, vifaranga wangu na mayai zote pia kabeba. Haya tika mama huyo.
Maumivu yakizidi, muone daktari.
Do you aspire to acquire knowledge and skills relevant to the job market and entrepreneurship? Join us at KIPS Technical College, one of the largest NEC examination centers in Kenya and the premier tertiary institution established and mandated to operate by TVET Authority. We lead when it comes to offering high-quality technical and professional training and bringing out the best in our students. Our ultra-modern learning facilities, highly qualified and experienced lecturers, attachment liaison office, counseling office make us the preferred choice. Limited HELB loans are available to students. Our intake is ongoing for full-time, evening and online classes. Join us today and experience the KIPS difference. KIPS KIPS Technical College, your sure path to success.
You are watching TV47, the home of untold stories.
Welcome back to the program. Now, 4 people have died in a road accident that occurred at a DC area in Makueni County after a lorry carrying sand lost direction and collided with a trailer along Mombasa-Nairobi Road. Now, among those who lost their lives are the trailer driver and 3 people who were in the lorry, and their bodies have been taken to Kilungu Mortuary as investigation continues.
Kuna lori ilikuwa inatoka njia ya Nairobi kuelekea Mombasa, trailer. Na kuna tipa ilikuwa inatokezea njia hiyo ya Mombasa Road, ilikuwa imebeba mchanga, ilikuwa inaelekea njia ya Malili, na hapo kufika hapo karibu kwa TZ Malili. Hapo ndio lori zilikutana chini ya mteremko. Harakati hiyo ya trailer ilikuwa inatokea njia ya Nairobi, alafu trailer ilikuwa inatokea chini huko sehemu za Mombasa, na ilikuwa imebeba mchanga, na hiyo lori trailer ilikuwa imebeba kokoto, na zikakutana, na kwa hivi sasa hivi yenye tunaongea hivi watu 4 wamepoteza maisha, wote wamepelekwa mortuary.
Now, as the 2022 presidential petition entered its 3rd and final day today, lawyers from both sides answered tough questions from the 7 judges who heard submissions for 3 days. Attorney General Paul Kihara, who was represented by lawyer George Oraro, insisted that he never attempted to influence the outcome. Hayamba Emmanuel with the report.
As the 2022 presidential petition entered its 3rd and final day on Friday, lawyers from both sides answered tough questions from the 7 judges who had submissions from Wednesday.
Let's be careful, and I humbly request particularly my learned colleagues on what we wish for this country.
Willis Otieno says Chebukati did not consult other commissioners before printing ballot papers, that his move to print extra results declaration forms was to influence the outcome.
To explain it in a layman's language, because this is very important that we understand. It's like saying, I have printed for every polling station 700 ballot papers.
George Oraro, on his side, defended the Attorney General, Paul Kihara, saying that his client was not aware of the winner of the election, ignoring allegations that he persuaded Chebukati to declare Raila as the winner.
So that even by the admission of the chairman, he was not aware of the results until after the NSAC team had left.
The question on whether the government attempted to influence the election took center stage, with the DP, through his lawyers, supporting IEBC chairperson Wafula Chebukati, who insisted that the National Security Advisory Council meeting was aimed at influencing the results.
Now, as we stated, the chairman is an eminent lawyer, qualified to be a Supreme Court judge. It is extremely unlikely he did not understand what Maina Kiai had told him.
Okiya Omtata also strongly objected to Wafula Chebukati's statement that he used the voter register as the denominator to determine voter turnout, as stated earlier by Chebukati.
There is a letter, a press statement signed by Mr. Chebukati, saying that he used the National Voter Register to calculate. And if I may just read it quickly to the court. So page 41 is handwritten.